All right, this is Senate Judiciary. We're taking up the committee bill on raise the age. And our next witness is gotta go to the next page, sorry. Evan Meenan, Deputy State's Attorney, representing the Office of State's Attorneys. Evan, go ahead, please.
Good morning, and thank you. For the record, my name is Evan Meenan, and I'm a Deputy State's Attorney in the Executive Director's Office of the Department of State's Attorneys. I'll start off with perhaps the most salient point, which is the department is largely supportive of this bill that you're taking up right now and agrees that the changes that are contained in it will be largely beneficial. So specifically, while the state's attorneys didn't ask themselves for a one-year pause in the implementation of Raise the Age, we certainly don't have any objections to it if it will help make Raise the Age successful. And whether that is 1 year or 2 years, as DCF has asked, that's acceptable to the department. The department is also supportive of the changes that were made concerning victims in these proceedings. It does think that some more work could be done to consolidate the victim-related language in these chapters, and it has been working with both the center and the network to put together some language for discussion in the juvenile jurisdiction work group. However, as flagged in both the department's November 4th and December 16th memos to this committee, we think that additional work can be done to improve how well both delinquency and youthful offender proceedings function. And those improvements will in turn hopefully make Raise the Age more successful. I'm not going to walk through all of the proposals contained in those memos again, but I'm certainly happy to answer any questions about them. As previously stated, the department also recognizes that some of the requested changes that it has made might be heavy lifts, and they might be too much to accomplish before you adjourn this coming spring. However, there has been some appetite expressed in the juvenile jurisdiction stakeholders work group to take a look at that issue and see how the relevant chapters can be reorganized and rewritten. And I'm certainly one of the people who is eager to engage in that exercise. That said, there's a couple of things that the department does think might be possible to accomplish before adjournment this spring, and I'd like to highlight those briefly. The first is in section 13 of the bill, which talks about what information courts should consider before granting someone youthful offender status. It's the department's position that the list that is in this bill is certainly a good one and will hopefully provide useful guidance to judges, but there's a couple other considerations that we'd like you to consider including. The first of which is the circumstances in which the alleged offense was committed, which is different than the nature of the crime that was committed. For example, someone can commit, as was discussed earlier this morning, someone could commit an aggravated domestic assault in a myriad of different ways, some of which might be more severe than others. And this additional consideration would allow that nuance. The second one would be an offender's criminal record, including any prior juvenile adjudications. Right now, this list allows courts to consider things like subsequent criminal or delinquent behavior, but it doesn't specifically include an alleged offender's criminal record. The input of any alleged victims would be another consideration.
Evan,
yes.
If I could just ask, are you talking about on page 16 and 17 of the bill?
I am, yes. Page 16, lines 13 through page 17, line 9. And
I
the
see.
department agrees that all of the factors there are certainly valid, and courts should have the ability to consider them. These are just additional things that we think courts might find helpful in making the public safety determination. So I believe I left off at the input of alleged victims, and I was going to move on to recent history of actual violence or threats of violence. There is item J on page 17, lines 8 to 9, the youth's history of violence of illegal or violent conduct involving firearms. That's a much narrower category, and at a minimum, the department questions why it should be restricted to firearms as opposed to other dangerous and deadly weapons, such as a knife or something similar. And then the final thing would be the results of any risk assessments that might be available at the time this determination is being made. The second thing that might be capable of being accomplished this session would be making a change that would allow the court to retain jurisdiction over a juvenile until the case is fully adjudicated and the term of supervision has expired. The rationale for this proposal is, if the idea is that a youthful offender status or a delinquency status is so much more beneficial to juveniles in terms of rehabilitation, why would we want to cut off that rehabilitation potentially prematurely? And there have been instances that have been brought to my attention in which a court has questioned whether or not YO status should be granted because there might not be enough time to complete the necessary rehabilitative services before the person would age out of jurisdiction. It would be unfortunate, in the department's opinion, to deprive someone of that opportunity and that status solely because there might not be enough time. The third thing would be, and the last 2 points pertain to this ping pong issue that I've attempted to raise and which State's Attorney Marthage has attempted to raise. We've had conversations with legislative counsel about potential solutions, some of which have become problematic because they end up opening up too many statutes that might need to be revisited during a comprehensive rewrite. But there might be two things we can accomplish. The first of which is to permit the court that is presently presiding over the case to preside over any motion to transfer the case. So for example, if charges are filed in the criminal division and there's a motion to transfer it to the family division, let the criminal division preside over that motion. Conversely, if the case is in the family division and the state's attorney seeks to move it to the criminal division, let the family division preside over that motion. Now, there may be circumstances in which it's actually the same judge, depending upon the size of the county that is hearing that hearing if they're assigned to both divisions, but that's not always true in every courthouse. The last thing would be to create a mechanism for a delinquency petition to be converted into a youthful offender proceeding without first having to go through the criminal division. This is something that State's Attorney Marthage has flagged. If there's a delinquency petition, in order to convert it to a youthful offender petition, the state has to first successfully get it transferred to the criminal division and then file a motion to convert it to a YO proceeding. That just adds an extra step that we think could be avoided. Those are the categories of additional items that the department thinks we might be able to address before May or early June potentially. And then I just have a few specific comments about DCF's proposal. And they're largely procedural, and the department is supportive of the language that they submitted in advance of today's hearing. The only thing that the department questions is organizationally, should their proposed amendment to 5281C1 actually appear in 5284, which outlines the considerations that a court must make when deciding to grant youthful offender status. And if and so that's the only comment. The only thing that I'd want to flag before I entertain additional questions has to do with the availability of a secure setting. And I know that Commissioner Brown and some other members from DCF are going to be testifying about that at noon. And I'm grateful for Senator Sears' comments about recognizing the need for that facility. I wanted to highlight the need by pointing out two things that you may not have become aware of and which states' attorneys are currently facing. The first of which is the additional time it takes to schedule and navigate the hearings under the Interstate Compact on juveniles when we need to send someone to a secure setting outside of Vermont, such as the Sununu Center in New Hampshire. The second thing is a requirement that has just recently come online under the Juvenile Justice and Delinquency Prevention Act, which is a federal law. That federal law is a mechanism for funneling certain types of funding to the state, but it has strings attached to it. And it says that, and those strings relate to hearings that must be held before a juvenile can be held in certain types of secure settings. In other words, if the state of Vermont doesn't want to risk jeopardizing this funding, it should start holding these hearings, even though there's not an independent legal obligation to hold them outside of this funding context. These types of hearings are also going to be adding additional process and additional court time, and it's going to be difficult to have them, if not impossible to have them, especially when a juvenile is apprehended after hours and we need a secure setting. My understanding is most states don't have to deal with this issue and putting that federal funding in jeopardy because they have in-state secure facilities specifically for juveniles. So I do agree that DCF and the sheriffs and the state's attorneys and the Department of Corrections are all doing a great job sort of managing the situation right now, but it takes a lot of resources and it could become unmanageable. And it has already started resulting in some burdens on hospital emergency rooms, which are becoming de facto secure settings in some cases. I know that there is at least one bill, which I looked at on Monday, H487, which would allocate over $3 million to DCF to fit up to 10 beds at the former Southeast State Correctional Facility for this very purpose. I don't know much about the current status of that facility, but I think both that proposal and the one Senator Sears has mentioned about using 4 beds in Rutland are the types of creative solutions that the department would like to see the legislature consider during the remainder of this session. Those are all of the comments that I had prepared, but I'm happy to answer any questions about what I just said or what I've outlined in the previous memos that I've submitted to this committee.
I know that Senator Benning is going to be holding hearings over the next 2 weeks regarding, I'm not clear exactly what they're going to be, so I'm going to ask him to comment if you'd like in terms of the secure setting. But what I think, given that Newberry is at least a year away, even if it ever happens, that I agree. We need to take action now. We cannot wait. In my community, as I already mentioned earlier, the hospital is being loaded with a number of dangerous youth who should be in a secure setting. And they're here because there's a lack of placement opportunities around the state right now. Joe, do you want to comment on that?
Yeah, the intent with institutions is to take a deeper dive on all of our brick and mortar and try to fashion a game plan for everything collectively. This afternoon, we're going to have I guess we'll call it a Plan B discussion as far as Newberry is concerned, but there's a much larger conversation to be had. I know that my counterpart in the House is going to get into this conversation as well. And Evan, if you want to be part of that conversation, I'll get you in touch with my committee assistant, Alex McCracken, and resist the urge to say, let's get McCracken and make communication with him. I've been biting my tongue. But this is a conversation that we're going to get into a deeper dive with respect to all the brick and mortar facilities. And if you'd like to be part of that, we'll get you in.
I would greatly appreciate that at a minimum, just so that I can stay in the loop and keep my folks briefed as to the state's efforts, because I know it's something that they are paying attention to as well. So thank you.
Any other questions for Evan or comments? I guess you heard my earlier conversation, and I hope you'll stay involved regarding the YO status and what can be done on DCF's recommendations. And I think it deserves a little more than what we can give it in this particular bill, but I agree it's a problem. I think there's also, I don't know, the geographic justice issues really strike me as something that between the judges, the defense bar, the state's attorneys, particularly those players, could all get together and figure out one straight strategy. I hope next week we're going to take up Senator Baruth's bill, which deals with it deals with the idea that you aggregate what somebody is stealing. So if they take a whole shopping cart of items and each individual item's worth $50, there may be about $5,000 worth of items in the shopping cart. But because we go by item, and that he would aggregate that. But I think it's an example of where in some counties, a $50 bad check will get you drawn to court or at least get you diversion, and in other counties it's just ignored. And so I think we need to, that issue of geographic justice needs to be dealt with.
And I'd be happy to participate in those conversations and try and offer useful suggestions. And I did hear the conversation about the ability to revoke YO status, and I'm happy to participate in that conversation as well. It has come up already in the juvenile justice stakeholders work group, and I can't take credit for this analysis. It is rightfully attributable to Judge Zone, who pointed out that there's two provisions that already exist in Vermont law, 33 VSA 5113 and 5283E, which potentially could be used as a mechanism for revisiting YO status. And he's on this hearing and can certainly correct me if I misstated that. So it's something that could be explored, but I think the fact that that was previously unidentified by so many people helps illustrate why taking a look at how these chapters are currently organized and written could be a valuable exercise, so that these types of tools are more readily visible to the people who are supposed to be implementing them. And we will, I will absolutely continue to think about how we can address DCF's issue. Thank you.
Okay, thank you. Any other questions for Evan? Thanks so much. Let's go to Judge Marshall Paul and then Judge Stoney.
Thank you. Good morning to the committee. I'm going to jump right in, and I have about 6 points I want to make. And the first two, also, first of all, I'll say just broadly that we are supportive of the bill. For the most part, as written. There's one little thing I want to touch on. And that, just find the section. It's in section 13, which is a section that we've talked about quite a bit. And I want to apologize to the other members of the stakeholders group. I'm doing something that I hate, which is bringing up something that I should have brought up during a stakeholders group meeting, but I didn't. Somehow this one slipped past me. I'm not sure when this was discussed or where it came from. But this is on page 16 on lines 14 and 15. We've included the language on the basis of available information. And I don't object to what I understand that's trying to accomplish, but my concern is that what that suggests is that the judge can make the decision on the basis of information that's not been admitted into evidence. This is an evidentiary proceeding, and the decision should be made only on the basis of evidence that is admitted during the proceeding and not on other information, even if it is available to the judge. And that's just a matter of basic due process and consistency, and making sure that things are transparent and that it's clear why judges are making the decisions that they're making, and that everybody has the opportunity to respond to the information that the judge is using to make that decision. So, I do have that concern about that line. I think that's easily fixed. It could be changed to something like on the basis of the evidence or on the basis of the available evidence, or just anything that makes it clear that that's not an invitation to consider information outside of the evidence. The other thing I wanted to touch on very briefly was just to answer some of Senator Sears' concerns about the psychosexual. I actually think that the line in the provision in here that allows judges to order psychosexuals after a merits proceeding for purposes of disposition is not necessary because they already have that power. There's a rule, I could try to pull it up, but it'd take me a minute. It's somewhere in Family Rule 1 that allows judges to order mental and physical examinations for purposes of disposition planning. And that's not limited in any way. It's not limited in any way that would prevent them from doing a psychosexual. And I understand Senator Sears' concerns about psychosexuals. I think that, as a matter of practice, it's understood that a psychosexual is very much different from, I think, what Senator Sears is referring to, which is a sexual risk evaluation. Those sexual risk assessments are actuarial assessments. They're done like a YASI. It's not something where the individual is examined and, they do some testing on the individual and the psychologist comes to a conclusion about that individual's risk level. Instead, what they do is take sort of objective criteria, number of offenses, history of offending behavior, history of being a victim of sexual offending, that kind of information. And then on the basis of actuarial data, they try to predict somebody's risk level. Those are the ones that are very much, those are very inappropriate on kids so far. Like so far, nobody's developed one of those that's accurate when it's used on juveniles. But the psychosexuals are very different. Those are an individualized assessment. It's like a full-on psychological profile. In fact, it contains just about all of the components of what we would really generally consider a forensic psychological profile, with the addition of a bunch of components about sexual offenses and sexual behavior. So I'm not at all concerned about the section in here that discusses psychosexuals. I am concerned about the way that information is used sometimes, but from my perspective, this is information that's already available and in fact is actually already we commonly get psychosexual evaluations for disposition purposes already, but it seemed that there was some lack of clarity around that, so people wanted that to be in the bill and we have no objection to it.
Okay. Well, that's helpful.
Those are my only 2 points about the bill as it's presented right here. My other 4 points are about DCF's proposal, and I'll jump right into them. The first is about the proposal to include reckless endangerment as one of the Big 12 offenses. And we would very much oppose that. Reckless endangerment, honestly, is a very, I don't know quite how to say this, but it's a very juvenile offense. It's very characteristic of juvenile behavior. I'll read you the elements of reckless endangerment. It's a person who recklessly engages in conduct which places or may place another person in danger of death or serious bodily injury. And that is, for example, I think it's long past the statute of limitations. So I can tell you that when I was a teenager, I certainly did all kinds of things that were very risky and placed other people in danger, messing around on ATVs and in cars and, playing with fireworks in ways that we definitely should not have. that certainly put people at risk of serious bodily injury. It is a very characteristically juvenile offense. This would loop in a lot of people who are charged with, doing really dumb things with, cars, ATVs, snowmobiles, doing dumb things with, I had a kid charged with reckless endangerment once for pushing another kid off of they were all cliff jumping, and one kid was scared to jump in and another kid pushed him in. Certainly something that the court should address, but not the kind of very serious, very dangerous behavior that should warrant an offense being lumped into the Big 12 and presumptively an adult offense. It would mean that would require every kid down to age 14 or 16, I think it's 14, to be charged in criminal court for any reckless endangerment charge. So that's a pretty heavy lift, and so we're very much opposed to that. The second one would be the proposal for quick denials of youthful offender status for kids who are already on youthful offender status. We oppose this, but we oppose it for the same reasons that DCF supports it. They're supporting it, thinking that it will create more uniformity in practice. We oppose it because we think it'll create less uniformity in practice. To our mind, giving judges the opportunity to sort of have two different procedural ways that they could go about deciding whether somebody gets youthful offender status or not. One way, by just simply saying, on the basis of what I've seen already, I don't need to see a report and I'm denying youthful offender status. And the other saying, no, I need to see a report. Just invites a situation where you're going to have different judges deciding to take those two different paths in very different circumstances. And I understand DCF's concerns. And I would very much, we've talked for years about coming up with a way, because their concern was that it takes about 6 hours to write one of these reports. And when it's, fruitless to write the report because the kid is already on youthful offender status and, it's going so poorly that it's clear that the kid's not going to be a good youthful offender candidate. That's a problem that we've known about since the beginning of the new youthful offender regime. And we've talked quite a bit about coming up with a way to reduce the amount of time it takes to write those reports, to come up with like a youthful offender light report for kids who are charged with less serious crimes. I think it's one of the points, and one of the things that's really you see reflected in DCF's proposals is there's been sort of a shift in DCF's thinking about youthful offender. If you remember, back when we were first doing youthful offender, DCF saw it specifically as a status for high risk, high needs youth charged with serious offenses. And in fact, there was discussion at that time about limiting youthful offender to only kids who had committed serious offenses and prohibiting kids who had lesser offenses from actually having access to the status. And we decided not to do that because we didn't want to create sort of a perverse incentive where defense attorneys would be trying to get their kids charged with higher offenses so that they could get youthful offender. And now we see sort of a shift where a shift in thinking, looking to try to exclude the more extreme offenses and exclude the kids who are sort of at the highest risk and highest needs, and focus the youthful offender attention more on the sort of lower risk, lower needs, misdemeanor offending kids. And so I think that's sort of what we see in a lot of these proposals, including this one. And so one of the things that I think that we could do, and it may not even require legislation. So it's something that we could work with DCF on, during the session, certainly, but also over the summer, is to just come up with a way for there to be shorter reports, or come up with a way for there to be an abbreviated report for less serious offenses, or to come up with there to be a way for the youthful offender consideration hearing to be a two-stage hearing, come up with some threshold factors, and then come up with, sort of a final group of factors so that the, kids who are clearly inappropriate for youthful offender status could be excluded at sort of a threshold level, at a threshold hearing. something along those lines. And that's something we could work with Dcf on going forward.
Can I just interrupt for a second, Marshall, to ask a question? Or comment?
Absolutely.
Sometimes it seems to me we ask for a change in law when a method already exists. And how do we prevent, going back to your reckless endangerment, and now your discussion on youthful offender, how do we prevent kids who are absolutely inappropriate for either delinquency proceedings and should be an adult, who may not have committed the Big 12, or a youthful offender kids who are absolutely shouldn't even be considered for youthful offender, but they are. Are there ways in the law now to help deal with that reckless endangerment example? Can a state's attorney, on their own volition, raise the issue that this kid, based on the background, based on the severity of the reckless endangerment, I get you're pushing off a cliff, but if that pushing off the cliff was done as bullying or some other behavior, maybe that kid needs to have some corrective action.
Absolutely. And that's really, I think, what this system is based around, is individualized determinations. And that's why we're so supportive of, if we have to, modifying the system that we have in place, but keeping the system we have in place, rather than making these sort of sweeping generalizations and saying nobody charged with reckless, there should be a presumption that kids charged with reckless endangerment belong in criminal court, even though that sweeps in a bunch of kids who really don't. That's why our proposal is to stick with our current system of individualized determination. And, frankly, I think there's never going to be a perfect system. It's all dependent on the people who are involved in it. There's prosecutors who, if there's going to be, if a kid's going to have youthful offender status denied because of this particular particular reckless endangerment offense was a very extreme or very severe one. For example, a kid pointing a gun at another kid can also be reckless endangerment. It's often charged as an attempted assault, but it can also be reckless endangerment. That requires a whole bunch of steps. I mean, a prosecutor has to raise that issue, a judge has to hear that issue, a judge has to decide that issue. If there's an appeal, the appellate court, it has to be raised on appeal, and then the appellate court has to tackle that issue. And so at every step of that, there's room for somebody to make a mistake, and there's room for kids to get youthful offender status inappropriately, and also room for kids to be denied youthful offender status inappropriately. And that will always happen. I mean, that's the nature of our legal system, is there's always going to be results that don't go as the law intended. And what we're trying to do is tinker with the system enough to, try to minimize those bad results. And my concern is making sure that what we're doing is making those adjustments in a very fine way, so that we're not saying, all right, we've had a few cases where kids got in with a reckless endangerment charge that was very severe and they shouldn't have. So we're going to sweep in all the kids with reckless endangerment charges and kick them out of YO, as opposed to saying, we just need to make sure that these issues are being raised and that they're being appealed if decisions are bad, and that the appellate courts are addressing it appropriately. And if we can provide more guidance in statute, but not making these sweeping changes and still relying on the courts and the prosecutors and the defense attorneys and DCF to make that individualized determination.
And Eric and Marshall and Evan, if he's still with us, or Judge, could we have a brief discussion of this tomorrow with the statutes in front of us, or Friday? I'd really like to better understand if there's enough flexibility in the system to allow for those individual decisions where, it can be, I think I only refused 1 or 2 kids in my time at 204 over 35, 40 years. But those 2 kids might have been one certainly ended up reasonable after he murdered two people, that I had declined to take him, but it was based upon the information, and we had the ability to say no. And I'm curious as to what's in statute now that would allow for discretion, and does the discretion need to be more explicit?
Just and I'm very much willing and happy to take part in those discussions, but just as sort of a data point, about 50% of youthful offender petitions that are filed are granted. So either judges or are denying about half of petitions are not being granted. That's a combination of judges denying them and defense attorneys withdrawing them. But so just, as far as, at a very rough level, you can look at that data and know pretty clearly that we don't have a problem where judges are just granting every youthful offender petition without looking at them or giving them due consideration.
Yeah, but I'm also talking about the delinquency proceedings that allow somebody to go from a delinquent act that's not a Big 12 to being dealt with in adult court, and how that happens.
Yep, and we can look at that as well.
I'm kind of referring to the reckless endangerment charge.
And that's,
Eric, you were going to comment?
Yeah, I was just going to add, Senator Sears, that, and this kind of, I think is something Marshall was alluding to as well, that the individualized determination, I think, is something that is really addressed by your adding of the public safety factors. These express list of factors that the court would consider. I think that almost automatically makes it a very individualized determination. You have to go through each of these factors and consider whether or not the person is appropriate for either youthful offender treatment, or, as you just mentioned, Senator Sears, in the section that was proposed to be added to the bill today, whether the case should be transferred from the family division to the criminal division. It added all those factors for the court to look at. And just something that occurred off the top of my head, it sort of also responded to what Evan was saying on page 16, the same page that I think Marshall was directing the committee to. If you look at one of those factors, 2A, line 16, one of the things the court has to consider is the nature of the charge and whether violence was involved. And you could add something like, and this maybe addresses the reckless endangerment hypo that Marshall was talking about, or the nature of the charge, and as Evan was saying, and the circumstances under which it was committed, including whether violence was involved. Something like that. Just something to think about to even more direct the court's attention toward the individual circumstances of each case.
Yeah, that's probably a really good suggestion.
And Senator, just to address, very briefly your question about reckless endangerment, that's not a charge that can be transferred because it's a 1-year misdemeanor. It's not a serious charge. So that charge can't be transferred. If it's a delinquency, if it's a kid who is under the age of 19, then there's no way to put it into criminal court. And that's, like I said, because it's a 1-year misdemeanor. It's not a serious offense.
Okay, great. Other questions? Oh, I'm sorry, Marshall. I interrupted you in the middle of your.
It's all right. I only had one more thing to talk about, and it's one that Attorney Micah has already she previewed my disagreement with it, which was the proposal to require conditional guilty pleas. We're of the opinion that if the conditional guilty pleas were reinstated, that we would be back to the situation we were in before, where youthful offender status is used very, very infrequently. And honestly, we think youthful offender status has been really great. It has been a tremendous benefit to the kids that we work with. And honestly, just listening, it was on a different subject, but we were just having that conversation about how we deal with kids who are under the age of 18 who in adult facilities. And the commissioner talked about how there's actually very few of those kids at this point. That wasn't always the case. That used to be very common that we had kids under 18 who were serving adult sentences. And the thing that's changed has been that we've expanded juvenile jurisdiction and we've expanded youthful offender. And that's really allowed us to come up with different ways to deal with a lot of kids who would have been going through the adult system years ago. So, you know, to our mind, keeping the youthful offender system vital is a really important part of this. And that proposal to require a conditional plea of guilty, we think is the same, you know, has the same problem as the other proposal. It sweeps in, like, in trying to get at one problem, which is a small subset of kids who get youthful offender status, and it turns out that they are not as amenable to treatment as it might seem. You know, in order to deal with that, it sweeps in basically everybody. You know, it sweeps in all the kids who would not take youthful offender status if that was a decision they had to make very early in a criminal case and enter a conditional plea of guilty for. And I also just wanted to push back a little bit on the idea that there's no consequences for kids, you know, refusing to engage in treatment or refusing to attend treatment or school. I've had kids who have had their youthful offender status revoked and been sent up for criminal sentencing and been sentenced to long terms of adult jail time because they failed to engage in treatment and failed to attend school as youthful offenders. It is, I would say, it's the most common probation violation we see, and it absolutely can lead to revocation. In fact, I would say it's the thing that we've seen that's led most commonly to revocation, because judges look at that and they see that if somebody is failing to attend treatment and failing to engage in treatment, that's sort of the core of youthful offender probation is treatment. And frankly, in a lot of cases, in most, I wouldn't say in most, in a real lot of cases, kids don't actually have a lot of time to get treatment in youthful offender status. It's very much a focus of youthful offender status is the pace of treatment, and judges monitor that pretty closely. DCF monitors that pretty closely. And when judges see kids who are going through treatment and are failing to engage in it, they're, I would say, pretty quick to pull the ripcord, because you know, that's almost always considered the most important part of youthful offender probation. So to my mind, that, you know, that proposal is not a good proposal because it would really eviscerate the youthful offender status and its usefulness. And then more to the point, it doesn't even really address the issue that, you know, it doesn't really address the issue of kids who are failing to engage in treatment, because right now we have kids, or, you know, prior to, like back when we had the requirement of a conditional plea of guilty, we still had plenty of kids who refused to engage in treatment. And you can expand that. If you look at our adult system, we have plenty of people who plead guilty and then fail to engage in treatment that's required by terms of their probation. I deal with that all the time. It's just not an uncommon thing. It exists in the juvenile system and it exists in the adult system. And it doesn't really address the problem of, the proposal for conditional pleas of guilty just really wouldn't address that problem. So we're very opposed to that, as Attorney Micah said we would be.
Well, I am too, but I need to better understand the requirement that the person be amenable to treatment to obtain the YO status, and then what happens when they're not amenable.
Yeah, you know,
Which leads me to that's really where the issue is. It's easy to say that the kid's amenable to, oh yeah, I'll go to treatment, I'll do whatever I need to do, and then not follow through on it. What happens then? And that's maybe that needs to be looked at.
I can't say what happens in every court, in every county, and with every DCF office, but in the counties I've worked, if that's what happens, the kid gets violated. And I would say that generally kids are getting at it. They're getting a shot. They're getting you get a violation, you go into court and the judge says, we're going to give you one more chance to engage in treatment. But if kids are continuing to fail to engage in treatment, they're getting violated and revoked.
Well, that's a good segue to Judge Zone.
Good morning, Tom Zone, Chief Superior Judge. And I had been monitoring early on by live stream watching, and then I think I'm going to develop this rule that anytime I hear Eric Fitzpatrick mention my name more than twice, I'm going to quickly sign on. So that explains why I jumped in quick. But I'll start out saying that I agree with much of what we heard here today, and in terms of the proposal that you're looking at, that Eric went through on the read-through, the stakeholder group worked on that and put together a number of changes, some of which we've heard that I suggested, that we talked about last time at the committee. We talked about language, and overall it works. It's an improvement on where we are. As far as the timelines, how far out, that's a decision for you to make. And we agree that there should be a definitive date. We think that's important. When I was listening today, I would agree, Marshall made a comment about the criteria that was put in with section 13 when he talked about on the basis of available information. And I would agree that he made a good point. And I think that if you made it that in there, if you wanted to change that to say on the basis of the evidence admitted or the available information admitted, that clarifies that issue. Likewise, when we're looking at that criteria, Evan Meenan talked about a number of changes. He mentioned, I believe in subsection A, that adding the word circumstances. Well, that would certainly be fine. And that actually would be somewhat consistent with other statutes that we have in the criminal realm in Title 13. When we look at bail and conditions of release, we have the nature and circumstances of the offense. So adding the word circumstances there would be consistent with other areas of the law. Looking at prior juvenile information, that certainly would be helpful for a judge. Any information that the judge gets and can consider as far as the criteria that's defined, it certainly is helpful for the judge making that decision. And I would note that when we were talking about the issue of, it kept going back to reckless endangerment, and how do you differentiate between, we'll call it the youthful exuberance and the serious crimes. Well, I agree with what Eric said. And that is, if you look at the criteria that you are now placing, if it goes through into the statute, it does have that ability for the judge to have that individualized determinations and make that decision. Was this someone being playful, as Marshall may have been in his youth? Or was it someone committing a serious offense that needs to be addressed such that public safety cannot be addressed? And so I think that is a place, as Eric said, that it does provide that ability for judges to say, no, this case is not there. And as Marshall pointed out, about 50% of the cases are not being found to be appropriate. And I don't have statistics on whether they're withdrawn or on what basis they're not there. But what it does show is, as Marshall said, and that is not every case is just getting rubber stamped. Judges are providing individualized views. And if there is a concern about situations for delinquencies on, again, to utilize reckless endangerment and them not possibly being able to go up, well, it might be best to consider changing that provision to allow that particular type of crime, or identify an offense category that can possibly go up when others can't. That gets rid of the situation where every case absolutely is, if you will, added to this list of Big 12. And it also would keep the individualized determinations there, where the judges would be able to ferret out on the basis of, again, what you're adopting, hopefully, for the criteria and the factors. And I'll touch on the DCF proposals, but before I touch on that, are there any questions that the committee has for me on what I've said so far?
No, I just, to make sure, Eric, have you been taking note of those, and perhaps to consider them tomorrow as changes to the bill that Judge Zone just mentioned, those three things?
Yep, sure have. I've been jotting them down as well. Thank you.
No, I think they're pretty self-explanatory. I'm struggling with reckless endangerment because I thought at first it was a good idea. Now I find it's, maybe not. And so how do we distinguish that behavior from where it's, youthful exuberance versus actual dangerous situations?
And I think the criteria that you have added or are looking at adding in the statute about can public safety be protected if it's that serious issue, that should provide a basis for the judge to say, no, this case doesn't go because of this serious issue. And it's as we, I think, all recognize in the criminal justice system, we have sometimes those cases where we say, okay, this is the forever rule for this category of cases. And yet we can always find exceptions. No matter which way we're going to look, we can say, well, boy, that's not what we intended. And so I think that if there's a mechanism within the existing statutes or with some minor changes to other statutes that can still effectuate the public safety, that is very important that you're highlighting with certain offenses such as reckless endangerment, and yet still permit the individualized attention and determination that the courts can make to further the goal of youthful offender and delinquency. I think that's probably a better way to go than to put in a blanket rule for every case that will be overly broad perhaps and capture cases that we would all agree probably shouldn't be prevented from the benefits that you have put into statute. The DCF proposal had something that I wanted to touch on right out of the blocks, and that is they want the court to be responsible for sending out the notice to tell the individuals that they have to go and have the risk assessments done within 15 days. And I haven't been testifying in my position very long before the legislature, but I didn't think that I'd be coming this soon going, yes, give more work to the clerks and the courts. But the reality is that provision makes sense. And the reason it makes sense is we can take care of the forms. We can add that to the paperwork that's sent out, and it provides a real procedure for knowing who's going to send this. Right now, we do have circumstances where there is some, I'll say, confusion as to, okay, who's going to let the juvenile, the youth know about they have to go for this report within 15 days. And then we have circumstances where it falls through the cracks. No one's let them know. We show up for the next hearing and it's not done. That's a waste of everyone's time. And there are some judges, and I'll actually mention one whose name we've heard here today, Judge Treadwell. Judge Treadwell has been using an order where he has done that in his courts. He sent that out to take the lead on that. And so I've checked with trial court operations, and I recognize again that it will be more work for the courts, but sometimes we as a justice partner and stakeholder have to say that we're the right entity to take care of that. And so I would say that we generally support that. It will take assistance from DCF to let us know where is the agency that's going to be doing this. For instance, when Judge Treadwell did it in Windham County, I'm aware that there was a set time, a set agency, everyone knew, and so the order could incorporate that. So we would expect DCF to be able to provide that to each of our courts. And then my thought is we'd work with our forms area, we'd have a form developed, and we'd have that form generated to make sure that it goes out. I would also note that in the future, if I tell you that adding something to the court is a bad idea, just remember that when it's a good idea, I'll tell you right away. Okay.
Okay, well, we'll try to remember that. You might need to remind us.
I'll do my best. The other component that the DCF proposal talked about was, I think Marshall referred to it as a short-firm rejection or short-firm denial. He makes a good point about that, and I would acknowledge I can envision that different judges would view it different ways. And we keep hearing, and Senator Sears, you talk about geographic justice, and I fundamentally agree with you that this is the state of Vermont. It's composed of 14 counties, and I recognize that we have different judges in all the counties. We have 14 elected state's attorneys, but we should have, to the extent possible, uniformity where our citizens are receiving justice in all the courts in a fair and uniform way as best we can do. And I can see where you might have some judges under this type of circumstance look at it and say, well, okay, they did, I looked at these factors, we're not having a hearing, denied. And yet I can look at some other judges who would say, no, we should have a hearing on this anyway, let's get the report done. And if the goal is to have us make the best decisions on the best information, truncating it ahead of time doesn't give us that, doesn't help us further that goal. Are there times that there's people who are youth who probably we could all look at and go, yeah, they shouldn't get it? Yeah, there are. And what I'm hearing is that it's 6 hours of work for DCF to do the report, and then the judge can have a hearing and make his or her decision. I suspect that there may be times where a quick look at something would lead a judge to think, we shouldn't go forward, they don't qualify. And yet, when we look at that individual and we get that report and we take a closer look at it, we realize that, you know what? Yeah, at first blush, this might not be someone who qualifies, but they do. And there's a reason we get to that. And so, as tempting as it can be for us to say, okay, no, we're going to just say this case doesn't go forward, I don't think it furthers what we're really trying to accomplish as much. And again, I'm not trying to put work on the courts, but if our goal is to do individualized determinations for the youth, which benefits not only them, but society, having a quick out without considering everything that can lead to differences of just judges' determinations or differences in geography, I'm not sure it furthers that. So I don't know that I support that provision the way it's currently written. There could be a way that I would support it possibly if it was reworded, but just overall to basically say, no, I looked at these factors, we're not even going to waste our time. I don't agree with that. I think we have to look closer. And beyond that, I don't have anything else I felt I needed to address unless you have any questions.
No, I don't. Other committee members? Thank you very much, Judge. Good to see you.
Thank you. Thank you very much.
Our next witnesses are Jennifer Coleman and I think Jessica Barquist may have some comments. But we'll start with Jen. And I do hope to be done by quarter of, so to give the committee a little bit of a break between the two meetings.
Good morning. For the record, I'm Jennifer Pullman with the Vermont Center for Crime Victim Services. Welcome back and Happy New Year. And I don't expect to take very much of the committee's time this morning. You've heard from us on these portions before. Certainly, we do support, the Center does support the reform efforts that have been taking place, and do think that this bill is a huge improvement in terms of bringing about more consistency and clarity with respect to victims' rights within Title 33. So we are not going to do a walkthrough, and I wasn't here for Eric's walkthrough this morning, so I don't know if there were any questions that came up in particular, and I think that's the main reason I'm here. You have seen that the changes that were made specifically to Section 3 with relative to victims' comp, wherein we did provide further definition to that piece about redaction, and also the piece around restitution in Section 4. We did restore that clause that was initially struck. We certainly don't want to be punitive or saddle young people with debts that they will never be able to pay. And I think that the bill, as you see it, represents some amazing work that you've already heard that the Juvenile Justice Work Group has done to really bring about a great deal of consensus. My only suggestion that I might offer relates to more of a technical question around technical suggestion around terminology. You'll see in Section 8, that's the provision that refers to the information from law enforcement agency. On page 7, line 19, the terminology of offender is used, and I would suggest that perhaps that be reflected to change, reflect what is in Title 13 and the terminology there. You'll see on page 8, line 4, the same piece references the offender's identity. as well as on line 6 and line 14. So I'm not sure if those were mentioned this morning, but that was something that I felt needed to reflect again the terminology that we use within Title 13. Otherwise, again, you've heard from us on these provisions. I think it is a really great process that we went through, and I'm really thankful to the committee for the time that you've taken to consider the suggestions that all of the work group has offered. I don't know if anybody has any larger questions for me.
Any questions? Thank you. As I was reading over the bill this morning and kind of glancing through it, I thought, oh my God, we turned it into a victims' rights bill. If you look at the sections that deal with victims, I think they're good changes. But it's interesting that almost 3/4 of the bill deals with victims and changes to the law that allow victims more access.
Well, we appreciate
Thank you.
that because, again, we agree with the concepts completely. From our perspective, it was just making sure that we're bringing victims' rights up to speed with respect to the reforms that are being put in place. So thank you very much.
Thank you. Next, Jessica Barquist from the network. Jess, thank you for joining us.
Hi, everyone. Thank you for having me. Jessica Barquist, Policy Director for the Vermont Network Against Domestic and Sexual Violence. And I will also be really brief. We support this draft. We think it's really strong legislation, and I really have no additional suggestions at this time, but would also be happy to answer any questions. And we just really appreciate the committee's time and consideration to these really important victims' issues.
Are there any questions from the committee? Thank you so much for your help with this bill. Appreciate it.
Thank you all.
Great. Committee, I just was looking at my email and there's a VSEA calls for urgent action to address crisis in DCF. So this, you may want to look at that before our noontime meeting. I assume everybody got it.
It's going to end up as part of our committee's deeper dive next week.
Well, I did send you the invitation. I don't know if they followed up on it on the meeting on the 10th.
With the VSEA?
No, with the local hospital.
Oh. I have not seen it.
Southwest Vermont Medical Center.
Okay.
The Bennington community has a number of programs for troubled youth that are being used in lieu of the secure placement. It's created issues in the local community with activity, assaultive nature, behavior.
Was that scheduled for Monday, Dick?
Yeah, I believe it's at 1 o'clock.
Okay. Unfortunately,
Oh,
I have court that day, all day.
oh,
And,
okay. Well,
I'm not going to be able to make it.
well, I'll try to relay to you and your committee the opportunity next week to talk a
I
little,
have pensions all day.
at least relay the concerns expressed by the local hospital and others.
Okay.
I think that's what Evan was referring to when he mentioned the hospital assaults. Eric, do you have anything final before we pick up here tomorrow morning?
Oh, just to understand what you're looking to see tomorrow, Senator Sears, just to incorporate some of the changes that were just discussed, I assume, which are virtually all of them are in that one section based on public safety that we were discussing. And
If you just could highlight the ability to move cases, I think it's 16 to 18 can be moved up to adult court. If you could highlight that process for us.
sure.
Because I'm forgetting what those criteria are, but it may help solve some of the concerns. And I think you're rightly pointed out that I think people are not looking at what the public safety aspect changes to the bill might might improve what they're concerned about in terms of like reckless endangerment or something.
Right. Yeah, those criteria we went over today are exactly relevant to that transfer that you're talking about, Senator Sears, from the Family Division to Criminal Division. So we can look at those again tomorrow.
Okay.
One last
Anything
quick
else?
question, though.
Yeah.
Did the committee reach a decision on the report language? Remember, there was
Yeah, I
talk-
think that Senator Baruth and White's suggestion is, if Senator Nicker opposes or Senator Benning, I'm fine with those changes personally.
I'm okay with that too.
Okay, great, thank you.
All right. See you in about 15